Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here in docket number 2021-88E. Today is August the 23rd. It's 9:10 a.m. Please forgive us for being late. We had some technical difficulties that we had to address, but I believe we are ready to move forward. Before we begin this morning, let's take roll. Present in the hearing room, we have Commissioners Caston, Williams, Belzer, Jay Williams. Joining us virtually, we have Commissioners Irvin, Thomas, and Powers. Before we broke for the weekend, we were at the applicant's last witness, I believe, witness Rooks. Is everyone ready to proceed?
Mr. Chairman.
Attorney Witt.
Apologize, but I have a oral motion that I need to make before the applicant rests its case. And so we'd like to make that motion at this time, if you will permit.
Okay.
Mr. Chairman and members of the commission, Richard Witt for Carolina's Clean Energy Business Association. The ground for my motion is R103-845C. And specifically from that reg, it reads as follows: in proceedings involving utilities, the commission shall require any party and Office of Regulatory Staff to file copies of testimony and exhibits and serve them on all other parties of record within a specified time in advance of the hearing. On this past Friday, the applicant's witness, David, made a substantial and material change to his pre-file rebuttal testimony related to interrogatory 2-14. Specifically, witness David made a substantive change to his rebuttal testimony in that he replaced a reference to one of the work papers the applicant had provided in June to an entirely different work paper provided in July in response to SCCBA 2-14. The new reference contains an entirely different and a major piece of analysis that SCCBA's witness, Burgess, did not have the notice of and did not have the chance to adequately consider and analyze when he prepared his rebuttal. As far as this material change, Mr. Chairman and members of the commission, in over 25 years of appearing before this commission, it has always been understood that the question that you've heard attorneys ask over and over again in the protocol leading up to putting testimony into evidence, is the question: do you have any corrections or changes to your testimony? It's always been meant to understand, do you have corrections to typos, or did you misspell Mississippi, or did you say that something occurred on July the 17th, 2021, and it occurred on July the 7th. And those kind of routine changes are made without a problem. The reason it's important for rebuttal testimony to be static and unchanged in a material way is because rebuttal is directly responsive to a witness's rebuttal, which was previously filed with commission. And in this case, there was a deviation, and it wasn't apparent to us until later in the day on Friday as to what had occurred. And this is our first opportunity to bring this to the commission's attention. So it's something particular to the commission. This is a commission regulation, shall require. As we sit here today, Mr. Chairman, members of the commission, the pre-filed testimony of witness David now contains information that wasn't pre-filed in advance of the hearing as required by the reg. As a result of this, that's a big disadvantage to SCCBA and its witness. And we'd like the following relief. We'd like the chance to do additional discovery directly related to the change that witness David made. We'd like the right to file supplemental testimony before the October hearing. And we'd like the right for witness Burgess, when he's called as witness later today or tomorrow, to briefly address the changes to witness David's testimony. And of course, after that, witness Davis could then be cross-examined in October. So that's the grounds for our motion and the relief sought for our motion. And we appreciate you hearing us, Mr. Chairman and members of the commission.
All right. Is there a response by the applicant?
Yes, Mr. Chairman, Mitch Willoughby on behalf of Dominion Energy, South Carolina. The testimony was nearly corrected. And while I've known Mr. Witt for all of those 25 years that he's been appearing to the commission, Mr. Witt and I used to practice law across the hall from one another, so we know each other very well. And I have a couple of years of additional practice before the commission. What Mr. David did was merely make a correction. It is important that testimony be accurate and express all of the information that the witness is planning to testify. And in the course of that preparation, Mr. David identified an error. Those errors were not as gigantic as Mr. Witt has made it out to be, nor has it in any way prejudiced the preparation of Mr. Burgess. Mr. Burgess had all of the work papers to which Mr. David referred. Mr. Burgess actually pointed out one of the errors in his testimony. So they were fully informed of what the testimony and opinions of Mr. David were. And what we wanted to do was purely correct the error so that when it's tendered into the record under oath, that the commission has an accurate portrayal of the witness's testimony. So, and I would also say, Mr. Chairman, that they had every right to cross-examine Mr. David. He was on the stand. They did cross-examine him. So they had the right to test that information, test the changes that were made through the point of cross-examination. And we would argue that the motion that has been advanced by Mr. Witt should therefore be denied.
Mr. Chairman.
Yes, sir.
If I may respond, we can have back and forth on this for the next hour, but nothing's going to change the fact that a substantive and material change was made, and that that's not what's anticipated when you say you have any changes or corrections. And so it puts us at an advantage. And with all due respect, Mr. Willoughby and his client don't get to grade how prejudiced we were by a change to interrogatory reference to interrogatory 2-14 that before was unimportant and was illustrative. And now it's become material in our opinion. And in fairness, I read you the regulation says that testimony has to be pre-filed. You have testimony before you today that was not pre-filed. So in the interest of due process and following this commission's long-standing regs, we don't believe you can make a change. Now, the applicant could have said, well, we have something we need to change or add, Mr. Chairman, ask for leave from the commission. And then he would, of course, said, and other parties have a chance to respond. But that didn't occur. It was just routine as it could be until later on when we had a chance to review it and find out that it is a substantive change and that our witness feels as if he needs more time to respond and a chance to do the things we requested for the October hearing. So the back and forth, I don't think is going to be helpful. The fact is the fact that they made a material change and we didn't have it in advance, and we would respectfully request the relief that we asked for, Mr. Chairman. Thank you.
Mr. Chairman, this is Bland Holman, if I might be heard, since I did the cross. And Mr. Willoughby just referred to the cross. And Mr. Willoughby just said that we knew in advance that these changes were coming. I think there are two things that are going on here, Mr. Chairman and members of the commission, that I'd like to clarify. This is Bland Holman for Pine Gate. One was a change dealing with hourly weighting. And we had pointed out, Mr. Burgess had pointed out in his testimony that the report said there was hourly rating, and then his subsequent testimony said they had abandoned hourly weighting. And we have issues with that. But Mr. Willoughby says they corrected that and removed the hourly rating references in the report. That's one thing. But the second thing they did on Friday, which kind of flew under the radar, was changing a reference to a spreadsheet, which was a response to discovery request 2-14. And folks, this is black box stuff. And what they've done is they changed the entire source of the analysis. Before they said the numbers came from a certain spreadsheet. Now they have changed the spreadsheet that it came from, an entirely new spreadsheet that they are referencing to. And that was entirely new. Mr. Willoughby, I don't think you ever, you gave signal in any testimony that you were going to make that change before you did that. And so I think that is the problem here, is that our witness was relying on something they said and submitted, and then they changed it. So all we're asking for is the ability to do a little discovery on that and to have him update his testimony based on an entirely new point that they made with this new reference to this different spreadsheet.
Mr. Chairman, may I respond briefly?
Yes.
So I don't think either Bland or Richard fully understands the change that was made. The change in the rebuttal testimony was simply to point to a different work paper. All of the work papers were previously provided. They had the work papers. They could look at all of the work papers. What they're trying to do is say we've done something underhanded. That's absolutely not true. There was no new information. The error in Mr. David's direct testimony that was corrected was discussed in his rebuttal testimony, and it was corrected in the rebuttal testimony. So that information was thoroughly available to them, and they even addressed it in their rebuttal testimony. There is absolutely nothing substantive about these changes. The entirely new spreadsheet that they received in discovery that was mentioned, they received in discovery back in July. They had all of the documents. They had all of the workbooks available to them for them to be able to look at and review and make a determination as to what they believe to be useful and important, and to do their own analysis. I would point out that they haven't done their own analysis. So in any event, there's no substantive change that's been made here. All of the information was fully available to them from which they could have done their analysis, and the fact that they didn't do it is not our problem. And we would therefore ask that the motion be denied.
Mr. Chairman, I just asked if Mr. Willoughby wants, there are two different issues and he is conflating them. One is the hourly waiting and the other is this reference to workbook 214. Mr. Willoughby, did you signal in before you made that correction that you were going to make that correction? I know you did with the hourly waiting because we pointed out the hourly rating had been abandoned, but with reference to workbook 214, the reference there, did you tell us in advance you were doing that? The answer is no.
Let me ask a couple of questions. Attorney Witt, Attorney Hallman, Attorney Willoughby asserts that you all had all the information that was referenced by their witness. Is that true? Did you have the workbook and the...
I'll say, Mr. Chairman, the problem is that our witness thought the workbook they had referenced was for illustrative purposes, and then the correction they made said, no, actually, that workbook is the whole thing we did. So the information was there, but it was kind of under the radar and hidden. And then they, at the last minute, say, no, that's actually the thing. That is the workbook that we were relying on. So our witness, he thought that was the sideshow, but it's the main show. So for them to change that at the very last minute, after our witness has already put all of his analysis in there, is entirely improper, and he should have the right. In fact, that they may have, at the last minute put that in there and it was in front of us, that is entirely beside the point of the statute, which your order in 2019 says they need to put this information up front in there, and to switch it at this point, it's way too late in the day. The fact that it may have been discernible in some kernel is beside the point that they said that was the sideshow. Now they say it's the main show. And Mr. Willoughby still not answered my question, which is, did they signal they were going to do that before they did that? The answer is no.
Mr. Chairman.
Well, I don't
Mr.
think.
Chairman, may I respond?
Well,
The
let's.
real-
Asked a question of me and Bland, Holman. May I respond?
Okay, let's slow down here a bit. You're right. I did ask a question to both you and Attorney Holman. Go ahead, Attorney Witt.
Thank you, Mr. Chairman. I appreciate it. Mr. Holman just gave the explanation twice now that before it was a reference, it was just a minor reference to illustrate something. And now with this change, they're saying that it's material and that's what it's based upon. And as I said earlier today, because I knew they'd be back and forth like this, the back and forth doesn't change the fact that you have testimony before you that was not pre-filed with the commission. This could have easily been handled by the applicant asking leave of the commission, leave of you, Mr. Chairman, to add, a change, and the other sides have a chance to respond. The fact that it was done the other way now means that as we sit here today, Regulation 103-845C has not been complied with, and that's all we're asking for is compliance. Thank you, Mr. Chairman.
All right.
Mr. Chairman, may I respond?
Yeah, I'll give you opportunity to respond, and then I'm going to rule. Go right ahead.
Yeah. So, Mr. Chairman, the reality is all of these workbooks were provided to Sasiba and Pine Gate back in the middle of July. They had all of that information. This is another example where they ask for information and sometimes don't review it or don't review it effectively. Mr. Burgess had the information, had all of the information available to him. We address much of the information in errors that they pointed out. We addressed in the rebuttal testimony. But for them to assert that they did not have the data and did not have the information is just absolutely incorrect. Now, the fact that they may not have appreciated the importance of the information, the fact that they didn't review the information, it's not our problem. But the fact that they had the information and didn't review it is entirely on their shoulders.
Understood. I understand both arguments in the interest of due process and given Attorney Witt's clients and Attorney Holman's clients opportunity to fully respond. I am going to grant their motion. Now, my question to you is this. How long will this take? We're on a tight schedule. So when you say additional time, how long will it take for your witness to review the information and be prepared to respond or testify?
Mr. Chairman, it's not going to take a lot of time today. What we had asked for was additional discovery, which won't affect this hearing, and the right to file supplemental testimony before the October hearing, which would only be fair. But today, witness Burgess was going to briefly address by Q&As the changes to witness David's testimony. And then, of course, witness Burgess can be cross-examined in October. So it will be a very minor addition to Mr. Burgess's summary when Attorney Burns puts him up today.
Understood. I also want the parties to address this issue, the issue of transparency in their proposed orders. This is not the first issue of transparency, if you will, that's been raised. It's the first time it's been raised to this level in this hearing. But at some point, I believe the parties need to get on the same page regarding transparency. It'll make the process run much smoother, in my opinion. So please address the issue of transparency in your proposed orders. All right.
Mr. Chairman, may I ask this question of the chair?
Yes, sir.
You've given privilege to Mr. Burgess to file supplemental testimony. We would request that same privilege once we get that supplemental testimony to be able to supplement the testimony of Mr. David in response to it. And I think Mr. Witt's motion indicated that that supplemental testimony would be, you planning to file it, Richard, today, or you planning to file it later?
It would be later. Today, he's just going to address in some short Q&As so as to not to delay the hearing, the change to witness David's testimony.
So, Mr. Chairman, what I understand then is when we come back in October to receive the independent expert's report, Mr. Witt wishes to then provide the supplemental testimony of Mr. Burgess. We would therefore also ask that we be able to file supplemental testimony to Mr. Burgess's supplemental testimony and present that in the October hearing when it is, I can't remember the date that it's scheduled, Mr. Chairman, but at that time be able to present that testimony.
Okay. Any objection to Dominion Energy South Carolina providing supplemental testimony to the supplemental testimony?
Mr. Chairman, this is Bland Holman. Respectfully, I would submit to you that what Mr. Burgess would be filing would be supplemental rebuttal, responding to the amended rebuttal testimony of Mr. David, which changed a lot, this major thing. To then reward Dominion by giving them a rebuttal to respond to Mr. Burgess, to me, seems to have it flipped it on its head. And I would respectfully object to that Mr. Burgess, after we get this discovery, which we could do quickly, hopefully, if the company is willing, get Mr. Burgess's updated rebuttal in the record. He can be crossed. That should be it. I don't understand why the company would get a rebuttal on top of that.
Attorney Holman, I agree. Attorney Willoughby, I respectfully deny your motion. Are we ready to proceed?
Yes, Your Honor. I think the next witness is Mr. Rooks, and Mr. Green is going to call Mr. Rooks.
All right. Thank you, gentlemen. Mr. Rooks, if you would please take the witness stand and pause to be sworn in by our court reporter.
Mr. Rooks, if you'll raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Rooks, please state your name for the record.
Alan W. Rooks.
And by whom are you employed and in what capacity?
I'm employed by Dominion Energy Services as Manager of Regulation for Dominion Energy South Carolina.
In connection with this proceeding, Mr. Rooks, did you prepare and cause to be filed direct testimony consisting of 7 pages?
I did.
Are there any corrections or changes to be made to that pre-filed direct testimony?
No, there are not.
Mr. Rooks, have I asked you the questions that appear in your pre-filed testimony today? Would your answers from the stand be the same?
They would.
Mr. Chairman, I would move the pre-filed direct testimony of Mr. Rooks into the record as if given orally from the stand.
The pre-filed direct testimony of Mr. Rooks is entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. And attached to your pre-filed direct testimony, Mr. Rooks, I believe were 8 exhibits. Is that correct?
That's correct.
Are there any corrections or changes to be made to those exhibits?
There are not.
Mr. Chairman, we would move as the next hearing exhibit the 8 exhibits attached to Mr. Rooks' pre-filed direct testimony. I think that's hearing exhibit 3, I think.
Actually 6.
6. I'm sorry, I got lost.
That's fine. I'm here to usher us through it. Rooks direct exhibits 1 through 8 will be marked as a composite exhibit and entered into the record as hearing exhibit 6.
Thank you, Mr. Chairman. Mr. Rooks, have you prepared a summary of your pre-filed direct testimony?
I have.
Please deliver that at this time.
Thank you. Good morning, Chairman Williams and members of the Commission. My name is Alan W. Rooks, and I'm Manager of Regulation for Dominion Energy Services on behalf of Dominion Energy South Carolina, Inc., or the company. In my direct testimony, I sponsor proposed updates to the company's 1, PR1 rate schedule for small power producers and cogenerators that are qualifying facilities. 2, rate PR avoided cost methodology rate schedule for determining avoided costs for power purchase agreements with small power producers. 3, rate PR standard offer rate schedule for small power producers up to 2 megawatts in size, and rate 4, rate PR form PPA rate schedule for qualifying power production facilities greater than 2 megawatts in size. My direct testimony, exhibit number AWR1 and 2, provide red line and clean versions of the company's current rate PR1 rate schedule, showing certain updates to reflect the company's current avoided costs. Exhibit number AWR3 and 4 provide red line and clean versions showing proposed updates to the company's rate PR avoided cost methodology. Exhibit numbers 5 and 6 provide a red line and clean version reflecting the company's proposed changes to its rate PR standard offer. Finally, my direct testimony exhibits 7 and 8 provide a red line and clean version of the company's proposed updates to its rate PR form PPA. I respectfully request that the Commission approve the proposed rate PR1, rate PR avoided cost methodology, rate PR standard offer, rate PR form PPA, and notice of commitment to sell form. The company requests that these changes be made effective with the first billing cycle of the month following the date of the Commission's order in this proceeding. Further, the company respectfully requests that the Commission find its proposals consistent with the requirements of Act Number 62 to be fair, reasonable, and in the public interest, and that they fully and accurately reflect the company's avoided costs. This concludes the summary of my direct testimony.
Thank you very much, Mr. Rooks. Did you also prepare in this case and cause to be filed rebuttal testimony consisting of 2 pages?
I did.
Are there any corrections or changes to be made to this rebuttal testimony?
No, there are not.
If I ask you the questions that appear in the rebuttal testimony, would your answers from the stand today be the same?
They would.
Mr. Chairman, I would move into the record as if given orally from the stand the pre-filed rebuttal testimony of Mr. Rooks.
The pre-filed rebuttal testimony of Mr. Rooks will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. And Mr. Rooks, attached to your pre-filed rebuttal testimony, I believe, were 4 exhibits. Is that correct?
That's correct.
Are there any corrections or changes to be made to those exhibits?
I have a change that needs to be made to each of the exhibits in question.
Okay. Please explain, I guess, the first change.
So with respect to rate PR1, which is presented in red line form in exhibit revised AWR1 and revised AWR2, I think exhibit 1 is the red line version, exhibit 2 is the clean version. I'll refer everyone to the clean version, probably for ease. And if we go to the capacity credit section, which is designated as section 2, under the monthly rate for non-solar qualifying facilities, the second sentence in the current version of that reads, in order to qualify for this credit, the seller's generation should be capable of providing power during all of the capacity credit hours noted above. This sentence should be stricken. And then if we move forward to exhibits revised AWR5 and revised AWR6, it's the same thing in section 2, where we talk about capacity credit. There's a sentence there that reads, in order to qualify for this credit, the seller's generation should be fully dispatchable during all of the capacity credit hours noted above. That sentence should be stricken as well in the standard offer tariff. So those were the 2 changes to those exhibits, and those are in response to the testimony of company witness Jim Neely under cross-examination from CCL counsel last week. But those are the only 2 corrections that I have for those particular exhibits.
Thank you, Mr. Rooks. And will you file or cause to be filed corrected versions of these 4 exhibits?
We certainly will.
Thank you, Mr. Rooks. Mr. Chairman, we would move as the next hearing exhibits, the 4 exhibits attached to Mr. Rooks' pre-filed rebuttal testimony as corrected from the state.
Mr. Rooks' pre-filed rebuttal exhibits, corrected exhibits will be entered into the record as a composite exhibit, and that will be hearing exhibit 7.
Thank you, Mr. Chairman. Mr. Rooks, have you prepared a summary of your rebuttal testimony?
I have.
Please deliver that at this time.
In my rebuttal testimony, I submit revised exhibit number AWR1, revised exhibit number revised AWR2, revised exhibit number revised AWR5, and revised exhibit number revised AWR6. These exhibits revise and are submitted in place of the corresponding exhibits that were attached to my direct testimony originally submitted in this matter on June 29th, 2021. The revisions to these exhibits were made to reflect updates explained in the rebuttal testimony of company witness Neely regarding the calculation of avoided capacity costs. Exhibits number AWR3, exhibit number AWR4, exhibit number AWR7, exhibit number AWR8 to my direct testimony remain unchanged at this time. This concludes a summary of my rebuttal testimony.
Thank you very much, Mr. Rooks. Mr. Chairman, Mr. Rooks is available for questions from the parties and from the commission.
Johnson Development Associates.
Chairman, good morning. Court Walsh for Johnson Development. We don't have any questions.
Carolina's Clean Energy Business Association.
No questions at this time, Mr. Chairman, from CCBA.
Pine Gate Renewables, LLC.
No, thank you, Mr. Chairman. Blanholman, Pine Gate, no questions. Thank you.
South Carolina Coastal Conservation League, Southern Alliance for Clean Energy.
Thank you, Mr. Chairman. Kate Mixon, First Ace and CCL, and we don't have any questions from Mr. Rooks.
South Carolina Department of Consumer Affairs.
Thank you, Mr. Chairman. Roger Hall for the department. We have no questions.
Office of Regulatory Staff.
Thank you, Mr. Chairman. This is Chris Huber for ORS. We have no questions from Mr. Rooks. Thank you.
Commissioners, questions for Mr. Rooks. Welcome. Oh, I'm sorry. Commissioner Williams.
Thank you. Hello, Mr. Rooks. Good to see you in this environment again.
It's you as well.
Thank you. I wondered if there was any way to look at the various impacts on a traditional size renewable energy provider and the changes that these rates will have on those providers.
So as we sit here today, Commissioner, the existing renewable energy generators that are currently interconnected to the DESC system, these rates would not change the avoided costs that are already contractually, specified for those generators. And just as a frame of reference, in calendar year 2020, we had about $57.3 million go through our fuel clause, and that was in avoided energy and avoided capacity credit payments to these existing generators. And so these avoided costs that are being addressed in this proceeding, specifically avoided energy, avoided capacity, would not be impacted by anything that we're deliberating here. The VIC, as currently constituted, is an interim VIC. And so just to give a frame of reference, the amount of VIC or VIC charges that went through fuel in calendar year 2020, same time period, was just less than $1 million. So a little less than 2% of the total payments that were paid out. And so to the extent that that VIC is trued up down the line, or a permanent VIC is established, what would happen is in the fuel clause, we would go back and examine all of the generation from those particular resources and go all the way back to May 2019 which is when that VIC that's the time period that we would use to go back and true up. And we would examine what was paid out under the interim VIC, and then we would compare that to what would be paid out under the new VIC and take that difference, and that would be applied to the fuel clause. So to the extent that the VIC is determined to increase from its current interim level, customers would receive an additional credit for the fuel clause. If the VIC were to decrease from its current interim level, the customers would see an increased charge to the fuel clause. So I hope that answers your question, and please let me know if that didn't.
I think that does. Thank you very much.
Mr. Chairman.
Commissioner Thomas.
Thank you. Good morning, Mr. Brooks. Can you hear me?
I can hear you just fine. Good morning. Good morning, Commissioner.
Thank you. I had a follow-up question here. So you mentioned the term, I believe, permanent VIC. If we get away from this interim, what does permanent VIC mean? I thought these numbers are updated on a fairly regular basis. So can you explain that to me, please?
I think that would be at such time as the commission determines that that there's a VIC that's permanent in nature, then we would go back and examine that VIC whenever that time will be in comparison to this interim VIC. So that it really meant no more than that, Commissioner.
Okay. But I guess the term permanent is, I guess I'm just kind of having a hard time understanding how that applies to the concept of the VIC. I mean, I know it could be long-term, but permanent seems a little bit strong. Do you understand what I'm saying?
Yeah, I think so. Maybe if permanent might not have been the best choice of words on my part, maybe it should be seen of as more as eliminating the interim nature of the current VIC.
Okay, thank you. That's all I have.
All right. Any other questions for Mr. Rooks? Mr. Rooks, I have a couple of questions for you. Just out of curiosity, do you have any thoughts or opinions regarding why no contracts for new solar generating facilities haven't been signed since our last of what it calls hearing?
Mr. Chairman, I don't know that I can add anything to what witness Cassis and other company witnesses have offered up on that matter. I suspect that as we continue to add more and more of the same type of resource on the system, that what we're seeing is that avoided costs have declined as we have more of these particular entities that aren't able to maybe shift that production into alternate periods. It's driving down the avoided energy costs in across these periods. So I certainly am no expert on economics of these particular developers, but certainly if that value is decreasing, that would certainly impact that analysis.
All right. Thank you, sir. If there are no more questions from the commissioners, we will go to redirect, if any.
Thank you, Mr. Chairman. No redirect, and we'd ask that the witness be excused.
Mr. Rooks, you are excused, sir. Thank you for your testimony.
Thank you, Mr. Chairman.
All right. Does the applicant have anything else for us today?
Mr. Chairman, that concludes the case of the applicant at this time, of course, subject to our participation in the independent analysis that the commission has secured and will present later on, and of course our participation in cross-examination of any supplemental testimony that Mr. Burgess may offer.
Understood, sir. So now, just to do some housekeeping, Johnson Development Associates, you do not have any witnesses, do you?
Mr. Chairman, that's correct. No witnesses for us.
All right. Based on the availability of witness Cersei, it was agreed that he would be called after the applicant rested their case or rested its case. Is Mr. Cersei available to be called to the witness stand?
Yes, Mr. Chairman, this is Kate Nixon, and Mr. Cersei is available. We're ready to present his testimony.
All right. If there are no objections, we will move forward with Mr. Cersei's testimony. Mr. Cersei, please take the witness stand and pause to be sworn in by the court reporter.
Mr. Cersei, please raise your hand, please. Right hand, I'm sorry. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir.
Thank you. Can you please state your name for the record?
Yes, Kenneth Cersei.
And by whom are you employed and in what capacity?
I am self-employed as an independent consultant.
Thank you. Starting with your direct testimony, Mr. Cersei, did you cause to be pre-filed in this docket on July 27th, 2021, direct testimony consisting of 36 pages?
Yes, I did.
And do you have any changes or corrections to your pre-filed direct testimony at this time?
No.
If the questions put to you in your testimony were asked of you at the hearing today, would your answers be the same?
Yes, they would.
And did you also attach to your direct testimony 8 exhibits, identified as exhibits KS-1 through KS-8?
Yes.
And were the exhibits to your testimony prepared by you or under your direction?
Yes.
Mr. Chairman, I would move to have Mr. Cersei's pre-filed direct testimony entered into the record as though given orally from the stand.
Mr. Cersei's pre-filed direct testimony is entered into the record as if given orally from the stand.
Thank you. I would also move to have exhibits KS-1 through KS-8 as attached to Mr. Cersei's pre-filed direct testimony entered into the record as the next composite hearing exhibit.
Exhibits KS-1 through KS-8 as found in Mr. Cersei's pre-filed direct testimony will be marked as a composite exhibit and entered into the record as hearing exhibit 8.
Thank you, Mr. Chairman. Moving on to Mr. Cersei's surrebuttal testimony. Mr. Cersei, did you also cause to be pre-filed in this docket on August 16th, 2021, surrebuttal testimony consisting of 26 pages?
Yes, I did.
And do you have any changes or corrections to your pre-filed surrebuttal testimony?
Yes, I have one small correction on page 22 in footnote 27. I cite to a commission directive. The docket number in that citation should read 2019-184-E, not 2021-88-E.
Thank you, Mr. Cersei. And we'll be happy to file a corrected version after Mr. Cersei's completed his testimony. Subject to that change, Mr. Cersei, if the questions put to you in your testimony were asked of you at the hearing today, would your answers be the same?
Yes, they would.
And did you also attach to your surrebuttal testimony one exhibit identified as exhibit KS-1?
Yes.
Was the exhibit to your surrebuttal testimony prepared by you or under your direction?
Yes.
Mr. Chairman, I would move to have Mr. Cersei's pre-filed surrebuttal testimony entered into the record as though given orally from the stand.
Mr. Cersei's pre-filed surrebuttal testimony will be entered into the record as if given orally from the stand.
And I would also move to have exhibit KS-1 as attached to Mr. Cersei's pre-filed surrebuttal testimony entered into the record as the next hearing exhibit.
Exhibit KS-1 as found in Mr. Cersei's pre-filed surrebuttal testimony will be marked and entered into the record as hearing exhibit 9.
Thank you, Mr. Chairman. Mr. Chairman, with your permission, we would like to present a joint summary of Mr. Searcy's direct and rebuttal testimony in question and answer format.
Please go right ahead.
Thank you. Mr. Searcy, can you please briefly describe your background and experience relevant to this proceeding?
Yes, I am an independent clean energy consultant with 10 years of experience, during which I have designed, run, and evaluated a variety of electric power modeling analyses, including production cost, capacity expansion, and avoided cost and related cost effectiveness tests. I have also evaluated cost recovery, resource planning, asset certification, program and tariff design in more than 60 regulated utility proceedings, primarily in South Carolina.
What issues did your direct and rebuttal testimony address?
In my direct and rebuttal testimony, I addressed several concerns I have with DESC's avoided cost rate proposals in light of the requirements of the South Carolina Energy Freedom Act and PURPA. My concerns fall under three broad categories: avoided energy, avoided capacity, and transparency.
So what were your concerns with the company's avoided energy costs?
I have three. Number one is the company's natural gas price forecast, which underlies its calculation of avoided energy costs. Number two, its 11 proposed pricing periods for the non-solar QF rate, which I argue are both illogical and unsupported by the company's data responses. And number three, the company's choice not to allow solar QFs to be eligible for the non-solar QF rate or the technology neutral rate.
What issues did you identify with the company's natural gas forecast?
In my direct testimony, I note that the natural gas pricing assumptions desk input into Plexos to develop its avoided costs were based on the same methodology rejected by this commission in the desk IRP proceeding. I recommend that desk recalculate its avoided energy rates using a blended forecast that uses NYMEX futures prices in the first year, and in year two, the midpoint between NYMEX and the EIA reference case prices, and for years 3 to 10, directly utilizes the EIA reference case prices. In my rebuttal testimony, I respond to desk witness Neely's claim that the company's method of applying the EIA escalation rate to current NYMEX prices is reasonable. The company's approach inappropriately overemphasizes short-term effects and thus produces an unreliable and ultimately lower forecast of gas prices. Contrary to witness Neely's claim, the blended approach I recommend ensures that short-term changes are captured while also more accurately forecasting long-term trends compared with DESC's current approach. It would also ensure consistency with DESC's IRP. As the company's witnesses have noted, the IRP and avoided cost proceedings are closely linked, and there is no valid rationale to have different natural gas forecasts for the different proceedings.
Mr. Searcy, can you please summarize your understanding of the purpose of pricing periods as you described in your testimony?
Sure. The purpose of pricing periods, as I understand it, is to ensure that prices paid to QFs are aligned with system costs. So hours and months that have similar costs are grouped together into pricing periods.
Could you please describe your concerns with the company's pricing periods?
In short, my testimony provides that neither the company's filings nor its discovery responses clarify how Dominion developed the 11 pricing periods under the standard offer rate. As I noted in my direct testimony, this directly contradicts the Commission's 2019 order requiring that the company provide further explanation about how it developed its pricing periods in its filings. Because none of the company's filings had this information, SACE and CCL requested in discovery, quote, all underlying data and analysis with formulas intact supporting the determination of the 11 pricing periods for the non-solar QF rates, end quote. In response, DESC provided a 12 by 24 heat map showing averages of hourly marginal prices across each month and hour, with boxes drawn on the heat map that correspond to the 11 proposed pricing periods. This spreadsheet also contained the underlying marginal price data from Plexos and calculations of average prices during the hours within each of the boxes drawn on the heat map. Their response contained no other explanation. The only reasonable conclusion I could reach was that DESC used the colors in the heat map to group similarly priced months and or hours together into pricing periods. Then they used those pricing period designations to calculate the average prices during the hours within each of the pricing periods. But a close review of that heat map reveals that in fact there are numerous instances where the coloration scheme is inconsistent. DESC witnesses Bell and Neely attempted to justify the pricing periods in their rebuttal, but their responses amounted to nothing more than saying the data supported the groupings. This was, again, devoid of any explanation of how the company grouped them together. And neither witness addressed my central concern, which was that the heat map which DESC relied upon to set its pricing periods did not accurately reflect the data that DESC provided. In creating its heat map, the company applied conditional formatting to each month separately rather than to its entire data set. They effectively created 12 separate heat maps, preventing comparison across months of the year, even though the company's pricing periods extend across multiple months. I created a heat map using the company's data that has a consistent color scheme throughout, and noted that neither the company's heat map nor its pricing periods reflected some of the seasonal and monthly variation in prices that were apparent in my version.
Thank you, Mr. Searcy. And setting aside the heat map coloration, did you also evaluate the company's proposed pricing periods using the hourly data the company provided?
Yes, I did. In my surrebuttal testimony, I conducted a statistical analysis, of DESC's proposed pricing periods, and I found that the prices within many of the company's individual pricing periods vary widely, and that the characteristics of the pricing periods are also quite different from each other. For example, some pricing periods contain hours with marginal system costs that differ by as much as $14. Since, as I understand it, the purpose of the pricing periods is to group together hours that have similar prices, this raised concerns about how Dominion grouped those hours and months into pricing period blocks.
Did Dominion explain how it grouped those hours and months into pricing period blocks?
No, since the pricing periods are not justified by an objective analysis, It appears that the company's methods were highly subjective. But again, the heat map and those underlying values were the only justification provided by the company. And then it was only in discovery, not in the company's testimony. As such, there remains no information in this proceeding about what subjective criteria the company used to group the hours into pricing period blocks.
The pricing periods were defined to include different sets of hours. Would the prices paid to QS change?
Yes, the price paid is the average of the prices from the hours included in each box. So if the boxes were drawn differently, the price paid to QFs would be different.
Do you recommend that Dominion be required to define those pricing periods differently?
Yes, I recommend that after Dominion reruns its Plexos modeling with reasonable natural gas price assumptions, as I discussed earlier, Dominion group its pricing periods together using an objective analytical approach that ensures that the hours within pricing periods are in fact similarly priced, as is the intent of pricing periods generally.
Mr. Searcy, could you please describe your testimony regarding the company's decision to make solar QFs ineligible for the non-solar QF rate, which you describe as a technology neutral rate?
Yes, in my direct testimony, I note that under DESC's proposal, solar QFs are paid a flat energy rate for, excuse me, all energy produced during a given year, regardless of whether the production profile of a given individual QF actually aligns well with the solar production profile assumed by the company. I recommend that solar QFs instead be eligible for the non-solar QF rate or technology neutral rate, which pays individual QFs based on when they actually generate electricity and thus better reflects the utility's avoided costs. In my surrebuttal, I dispute witness Neely's claim that using my recommendation would not accurately compensate solar QFs. QFs would be more accurately compensated under the time of production approach of the technology neutral rate. In fact, in the 2019 avoided cost proceedings, this commission approved this technology neutral approach for both Dominion and the Duke Energy operating companies. Further, while witness Neely claims that the solar only rate is needed due to the amount of solar on DESC's system and dispatch requirements, the modeling used to develop the technology neutral rate already accounts for the existing solar on DESC's system. And DESC is also proposing a variable integration charge, which it claims would capture the impacts of solar variability.
Could you please describe your concerns with the company's avoided capacity rates?
Sure. I raised three concerns relating to DESC's proposed avoided capacity rates. First, I believe they do not put QFs on equal footing with utility-owned resources. Second, I believe the company used overly low capital cost assumptions. And third, I take issue with the company's decision to allocate all capacity to the winter season.
Starting with number one, why do you believe the company's avoided capacity rates do not put QFs on equal footing with utility-owned resources?
First, DESC's proposal would only compensate QFs at the full avoided capacity rate if they generate during all avoided capacity payment hours. This is not true of utility-owned resources. All technologies are subject to forced outages, and sometimes those outages occur during peak periods when system capacity is most needed. However, the utility still gets full cost recovery for those resources. To put QFs on equal footing with utility-owned resources, as contemplated by Act 62, I recommend applying a performance adjustment factor, which is essentially a multiplier of 1.05 to the final capital cost value used to develop the avoided capacity rates. The Commission already approved this approach for Duke Energy, finding that a PAF of 1.05 was reasonable and supported the goal within Act 62 of putting QFs on equal footing with utility-owned resources. In response to my recommendation to apply a PAF, Witness Neely's rebuttal suggested that doing so would penalize desk-owned generators. But as I note in my rebuttal, a PAF doesn't have any impact on desk-owned generators. It simply adjusts the possible avoided capacity compensation for QFs to treat the QFs equally with desks generators. My direct testimony pointed out that DESK's standard offer rate stated that QFs would not receive any compensation unless they were available and dispatchable during all 270 capacity payment hours. Though I understand from Mr. Neely's testimony and Mr. Rook's testimony earlier that that was a mistake in Dominion's tariff and will be corrected.
What are your concerns with the company's capital cost assumptions?
DESK used unreasonably low capital cost assumptions in its avoided capacity calculation when compared to Aero CT capital costs and fixed O&M data published by the EIA, a respected public industry data source. I recommend DESK revise its avoided capacity calculations using those EIA data points to ensure more accurate avoided costs. This approach would also be consistent with the Commission's order requiring Dominion to revise its ICT cost assumptions in the 2020 IRP proceeding.
Thank you, Mr. Searcy. And what are your concerns with the company's decision to allocate all capacity value to the winter season?
For the technology neutral capacity rates, DESK allocates all capacity value to a 3-hour period during the winter season without justification, and despite the fact that DESK has experienced more summer peaks in the last decade than winter peaks. To remedy this concern, I recommend making standalone solar QFs eligible for the technology neutral capacity rate and adjusting that rate to account for DESK's summer and winter peaks. Under this recommended approach, an example solar QF would receive about 19% of possible capacity value, as opposed to the 5% proposed by DESK. Witness Neely's rebuttal failed to justify why DESK allocated 100% of capacity value to the winter season under the technology neutral rate. As I note in my rebuttal testimony, despite the seasonal reserve margin differences and the level of existing solar on DESK's system, the expansion plan used by DESK to calculate avoided capacity costs shows that the DESK system has both a summer and a winter capacity need at the same time. Further, DESK's 100% winter season capacity allocation is at odds with the load patterns on its system. Desk has experienced more summer peaks than winter peaks in recent years, and the top 1% of load hours on the system include a very large number of hours during summer afternoons. In contrast, the capacity rate approach recommended in my direct testimony reflects these load patterns while also accounting for the existing solar capacity on the system. Under this revised rate, QFs would be paid based on when they generate. And if they do not generate during winter morning hours, they will not be paid for those hours.
Thank you. Mr. Searcy, what are your concerns with the company's effective load carrying capability, or ELCC methodology?
Sure. DESC uses an ELCC methodology for capacity accreditation for solar QFs. But DESC's testimony and discovery provides only a brief overview of the ELCC methodology, leaving out essential details needed to actually evaluate the analysis. The details I did have suggest a troubling lack of rigor in DESC's ELCC calculation. This lack of transparency and rigor is particularly concerning given the DESC's proposed ELCC of 5% is significantly lower than accreditation values included in a respected organization's study of peer Southeastern utility systems. In my rebuttal, I continue to recommend that DESC be required to employ best practices when developing the ELCC. More rigorous ELCC methodologies yield more accurate and reliable results. I also note that DESC should have included information about its ELCC in its filings rather than only in discovery, and that I was unable to evaluate the full details of its ELCC calculation despite our data requests asking for, quote, all underlying data and analysis, end quote, on how DESC did that calculation.
Finally, Mr. Searcy, could you explain why you believe the company's application and testimony was not transparent?
Put bluntly, DESC's application and testimony do not provide information about fundamental aspects of its proposal, such as its natural gas price forecast, the methodology used to develop its pricing periods, or the details of its ELCC calculations, all of which have a significant bearing on the accuracy of its avoided cost rates. Even where the company provided some data and discovery, key information still remains unclear or remains missing, and those discovery responses are not available to the Commission for their evaluation of the company's proposal.
Thank you, Mr. Searcy. Does that conclude your summary?
Yes, it does.
Mr. Chairman, the witness is now available for cross-examination and questions from the Commission.
Excuse me, Johnson Development Associates.
Mr. Chairman, no questions from Johnson Development.
Carolina's Clean Energy Business Association.
Sorry, Mr. Chairman, I was on mute. We have no questions for this witness.
Pine Gate Renewables.
Mr. Chairman, Bland Holman for Pine Gate, no questions. Thank you.
South Carolina Department of Consumer Affairs.
No questions, Mr. Chairman. Thank you.
Office of Regulatory Staff.
Thank you, Mr. Chairman. This is Chris Huber for ORS. We have no questions for this witness. Thank you.
Commissioners, questions for Mr. Searcy. Commissioner Caston.
Mr. Chairman, this is Chad Burgess. Before Commissioner Caston asks his questions, would it be all right if the company cross-examine this witness?
It would totally be all right. And Chad, I'm sorry for forgetting about the applicant.
But hey, that is quite all right, Mr. Chairman. There's a lot of parties in this case, and we all work together to stay on the same page, so no worries on our end.
All
Hey,
right.
good morning, Mr. Searcy.
Good morning, Mr. Burgess.
We know each other, so no introductions are necessary. It's nice to see you again, and I hope you're doing well, and I hope things are going great for you out in Colorado. I've got just a few questions that I want to put to you this morning with respect to your testimony. Now, as I understand your testimony, Mr. Searcy, you are testifying on behalf of the South Carolina Coastal Conservation League and the Southern Alliance for Clean Energy. Is that correct?
That's correct.
And when did, and I'll just use their acronym, CCL and SACE, if that's all right with you. When did CCL and SACE retain your services for this proceeding?
I don't know if I recall the exact date. Let's see. I think it was sometime in July. It may have been June.
That would be July or June of 2021. Is that correct?
Yes, that's correct. I'd have to check my records to get the exact date.
Okay, that's all right. And I presume that CCL and SACE are paying you for your services. Is that correct?
Yes.
And what is your hourly rate if that's the structure by which you're being compensated, Mr. Searcy?
My hourly rate varies by the type of task. So there's a differentiated hourly rate based on different tasks within this project.
Okay.
Mr. Chairman, I would object. I'd love to see how this question is relevant to Mr. Searcy's testimony. He's already testified that he is paid for his services. I don't know why the exact rate is relevant.
Well, Mr. Chairman, I think he answered the question, so I can accept his response that he's paid a different hourly rate depending upon the services for which he's hired for.
All right. I don't see any issue with the question or the answer, Attorney Mixon, unless there's something else that we need to consider.
That's all, Mr. Chairman.
All right. Thank you.
Okay. Thank you, Mr. Searcy. I understand. Okay. So I understood your answer to be that depending upon the services for which you're hired, that determines what your rate is. So what services did CCL and SACE retain you for in this proceeding?
For providing testimony at this hearing, for developing that testimony, including review of the company's filings and analysis of its proposal, development of any alternative proposals or recommendations.
And you understand, do you not, Mr. Searcy, that the company filed its application in April of this year? Is that correct?
Yes.
And you began your work in June or July, I think it's what you testified. Is that correct?
Yes.
Okay. Now, you also attached a CV to your direct testimony. Is that correct?
That's correct.
And your CV states that you are a consultant in the energy power sector. Is that correct?
Yes, that's correct.
In fact, you state on your CV, Mr. Searcy, that you are an independent consultant. And I think you actually stated that a couple times during your summary. Is that correct?
Yes.
And did I hear you correctly that you state you've been an independent consultant for 10 years? Did I hear that right?
No, I've not been an independent consultant for 10 years. I've been an independent consultant for about 3 years now.
Okay, thank you. I'm sorry, I misheard that. Okay, 3 years. Now, prior to becoming an independent consultant, you were an employee of the Coastal Conservation League. Is that correct?
That is correct.
And when did you work for CCL?
2012 to 2018.
All right. And as I looked at your CV, Mr. Searcy, I see where you've only testified on behalf of CCL and SACE and also the Solar Business Alliance. Did I read that correctly?
That's correct.
Have you ever provided testimony on behalf of an entity other than the ones I just mentioned in my previous question?
No, I haven't.
And have you ever testified on behalf of a utility?
No, I haven't.
And have you ever testified on behalf of a state agency such as ORS or the Department of Consumer Affairs or a state agency that functions in their capacity?
No.
And have you ever been hired by any entity other than CCL, SACE, or the Solar Business Alliance?
As an independent consultant, yes.
Okay. And who have you been hired by?
I've been hired by some consulting firms. Trying to run through my client list in my head. Consulting firms, clean energy businesses, clean energy trade associations, conservation groups. I think that covers it.
Okay, so I want to make sure I've got this right, Mr. Searcy. So you worked for CCL as an employee from 2012 to 2018, roughly 6 years. And then in 2018, you became an independent consultant. And during those 3 years, you've only testified on behalf of CCL, SACE, and the Solar Business Alliance, but you have not been retained by a utility. Is that correct?
That's correct.
Mr. Searcy, you're not really an independent consultant, are you?
I believe I'm an independent consultant. I'm not employed by another consulting firm as a full-time employee. I'm self-employed as a consultant.
But as I understand your testimony correctly, Mr. Searcy, you've only testified on behalf of entities that have an interest in advocating for higher avoided costs, but it's your testimony today that you still believe you're an independent consultant.
Well, I've had a number of different clients over the years as a consultant, and I've done my best to meet the requests of my clients, and I think I've done that in a balanced manner with a high level of integrity.
Now, Mr. Searcy, as I understand it correctly, you did not file testimony in this proceeding on behalf of the Carolinas Clean Energy Business Association, did you?
That's correct.
And I'll refer to them as SECIBA. Did SECIBA retain your services for this proceeding?
No, they did not.
Okay, well, help me understand the following, Mr. Searcy. Do you recall signing a confidentiality agreement between SECIBA and Dominion Energy South Carolina for this proceeding?
I believe I may have. I signed a lot of confidentiality agreements. I'd have to check my files to verify.
Well, no need to check your file. I'm going to show you a document right here in 1 second. I'm going to attempt to share my screen, Mr. Chairman. Okay, Mr. Searcy, can you see the screen okay?
Yes, I can.
Okay, and Mr. Chairman, can you and the other commissioners in the hearing room see the screen okay?
No, sir.
Try to. All right. Can you see that, Mr. Chairman?
Yes, sir.
Okay, so Mr. Searcy, I would represent to you that this is an email that counsel for Dominion Energy South Carolina, including myself, received from Carrie Sherg. Do you know who Carrie Sherg is?
Yes, I do.
And who is Ms. Sherg?
She works for Richard Witt's law firm.
And Mr. Witt is counsel for Sasiba in this case, is he not?
Yes.
Okay, and this email was sent to Matthew Gissendanner. And do you know who Matthew Gissendanner is, Mr. Searcy?
Yes, I do.
And Mr. Gissendanner is in-house corporate counsel for Dominion Energy South Carolina Institute.
Yes.
Okay, and this email states as follows: Matt, attached, please see Richard's signature page to the NDA for Sasiba and additional signature pages for John Burns, Hamilton Davis, Kenneth Searcy, and Ben Snowden. Regards, Carrie Sherg. Did I read that correctly, Mr. Searcy?
Yes.
Okay, I'm going to try to share my screen one more time here. Okay, Mr. Searcy, can you see this document that's on the screen here?
I can.
Okay, and Mr. Chairman, can you and the other members of the commission here see this document on the screen?
Yes.
Okay, very good. Thank you. So, Mr. Searcy, this is the confidentiality agreement between Sasiba and DESC. And I'm just going to scroll down here. Now I'm going to take a cue from Mr. Burns, try not to make everybody dizzy, but I'm just going to scroll down here to the signature pages. Okay, so this is the first signature page, and this is the signature of Richard Witt, who we've established as the counsel for Carolina's Clean Energy Business Association. And then, Mr. Searcy, we've got Mr. Gissendanner's signature page on the confidentiality agreement between Sasiba and DESC. And now we have an additional party agreement, and this is the signature of John Burns, who we all know is in-house, is the general counsel, for Sasiba. And then we come to Hamilton Davis. Now, who is Hamilton Davis, Mr. Searcy? Do you know him?
I do. Hamilton Davis works for Southern Current LLC.
Okay. And now we come to this signature page, Mr. Searcy, and it has your name printed on it. Is that your signature, Mr. Searcy?
Yes, it is.
Okay. And then we got one last signature here, Benjamin Snowden. Do you know Mr. Snowden?
I do.
And who is Mr. Snowden?
He's an attorney who represents SBA or Sasiba.
Mr. Chairman, this is Kate Mixon. If it would help to clarify things, I'd be more than happy to briefly explain the situation here. It was simply
Mr. Chairman, with all due respect, I'm sure Ms. Mixon might be able to explain this, but I would like to ask the witness to explain this, and I'm getting to that point.
Yeah, I would agree. I mean, is there an objection, Attorney Mixon?
I mean, I would pose a kind of given the reasons for this line of questioning is relevant, that it has nothing to do with Mr. Searcy's filed testimony in this proceeding. That's my objection.
Well, Mr. Chairman, with all due respect to Ms. Mixon, I do believe this is information, this is relevant. I asked the witness if he was hired by SECIBA in this proceeding. He said no. And I'm simply presenting documents that show otherwise. And I would ask that you overrule the objection.
Objection overruled. Please proceed.
Thank you, Mr. Chairman. So, Mr. Searcy, can you please explain to me, you said earlier that you were not retained by SECIBA in this proceeding. So can you explain to me and the commission why you would execute a confidentiality agreement as an additional party between SECIBA and DESC?
As part of some of my client work with solar companies in South Carolina, I was asked to sign the agreement in case they decided to ask me to review something in the case. I don't think that ever actually happened. I did sign the agreement as we saw, but I don't think that they ever asked me to review something in this case or paid me to do so.
Is it normal for you to sign agreements on behalf of parties who don't hire you for your services?
I don't know if I've done that before. This just may be the only instance that I can think of.
Okay. But just so we're clear, you have not been hired by SECIBA, but nonetheless, you execute documents in furtherance of SECIBA. Is that correct?
I wasn't hired by SECIBA to work on this case.
Thank you, Mr. Searcy. Mr. Searcy, do you have your direct testimony handy?
I do.
Okay. And I think you covered this when you were giving your summary, but I want to make sure. Let me direct you to page 1, line 13 through 17 of your direct testimony. Let me know when you're there.
Okay.
Okay. You state in your direct testimony, I have designed, run, and evaluated a variety of electric power modeling analyses, including production cost, capacity expansion, and avoided cost and related cost effectiveness tests, and have evaluated cost recovery, resource planning, asset certification, program and tariff design in more than 60 regulated proceedings, primarily in South Carolina. Did I read that correctly, Mr. Searcy?
Yes.
So based upon your own testimony, you clearly know how to run an avoided cost analysis, correct?
Yes, I would say so.
Okay. And you would agree with me, would you not, that an avoided cost rate consists of avoided energy and avoided capacity costs, correct?
Yes.
And this proceeding is about the cost that a utility avoids, is that correct?
That's correct.
All right. Now I want to talk with you about avoided capacity costs very briefly. So in your testimony, you are recommending that the commission apply a performance adjustment factor that would have the effect of increasing DESC's avoided capacity costs, correct?
Well, it would have the effect of increasing the possible avoided capacity compensation to QFs to put them on equal footing with utility-owned resources.
That's right. So you agree with me that would have the effect of increasing avoided capacity costs, correct?
Yes.
Okay. So in other words, you would like for DESC's customers to pay more for capacity costs than they otherwise would under DESC and ORS's proposals in this docket, correct?
Well, my testimony is making that recommendation because it is in line with the Act 62 requirement that QFs be treated on equal footing with utility-owned resources. And if we don't include a PAF, they will not be treated on equal footing with utility resources.
That's right. There's also, I believe, 4 other things that Act 62 requires this commission to look at. So it's not just only looking at the small power producers, is it, Mr. Searcy? They have to look at ratepayers, right?
Yes.
Okay, thank you, Mr. Searcy. Now, the performance adjustment factor that you're recommending, that's not a cost that DESC incurs today, is it?
Well, it relates to the performance of the utilities resources and the QFs. So the utility resource, you don't get 100% performance for it. So you can calculate an avoided cost for utility resource, but you're not getting 100% performance for that avoided cost. You're only getting about 95% performance. So what the PAF is doing is saying, okay, I've calculated my avoided costs, and now in order to make the QF fully on equal footing with the utility resource, I have to allow the QF to be as unavailable as the utility resource would be. So the QF has to be allowed to be 95% available and still get fully compensated just as a utility resource would. And so that's what the PAF accomplishes.
So, Mr. Searcy, if I understand your testimony correctly, the PAF is really nothing more than an arbitrary number that is designed to inflate the utility's avoided capacity cost for the sole benefit of QF. Isn't that correct?
No, it's not.
Mr. Searcy,
It's not an arbitrary number. It's a number that is based on the utility resource availability.
But the performance adjustment factor, that's not a cost that DESC incurs today. You won't find that in the company's rates, would you?
Well, by definition, it's not a cost. It relates to the performance of the resources.
Thank you for pointing that out, Mr. Searcy. You are familiar with the Energy Freedom Act, correct?
Yes, I am.
Okay. I'm going to pull up the Energy Freedom Act here real quick. Bear with me 1 second here. Okay, Mr. Searcy, can you see my screen and I'll make it a little bit larger? Can you see that okay, Mr. Searcy?
No, it's pretty small.
How about that? Can you see that okay?
That's better. It's still pretty small as it's showing.
I'm sorry. I know you sound like me when I'm at the eye doctor's office and I can't read the chart. So all right, let me just go 200%. I think Mr. Burns tried to teach me that earlier in the proceeding. How about that? Can you see that okay?
I think I can see that well enough to follow what you want to read here.
Okay, very good. Mr. Chairman, is that okay for you and the other commissioners in the room?
Yes, sir.
Okay. Okay, thank you. All right, so Mr. Searcy, this is section 5841-10 of the Energy Freedom Act, and this is the definition of avoided cost. Would you mind reading to me the definition of avoided cost for the benefit of the commission?
Sure. Avoided cost means the incremental cost to an electric utility of electric energy or capacity or both, which, but for the purchase from the qualifying facility or qualifying facilities, such utility would generate itself or purchase from another source.
All right, thank you, Mr. Searcy. And I want to be crystal clear with this next question. What cost is the performance adjustment factor avoiding for DESC?
So the performance adjustment factor is part of a set of calculations that ultimately go into avoided cost rates and tariffs, right? The avoided cost rates and tariffs have to comply with Act 62. And part of that is identifying, avoided costs themselves, but part of it is complying with all the different elements of Act 62. The one that I call out in my testimony that's important in this avoided capacity part of the avoided cost rates is the requirement to treat QFs equally with utility resources. And in order to do that, a PAF is necessary to, again, reflect the unavailability of utility resources.
Okay, I'm glad you brought that up, Mr. Searcy. So let's, again, you have your direct testimony here in front of you?
I do.
All right, so let's look at page 4 of your direct testimony. And if I'm reading this right, on lines 8 through 16, are you with me?
I'm getting there. Okay, page 4, 8 through 16. Yes.
Right, and this is the section of the Energy Freedom Act that you are claiming that small power producers must be treated on equal footing. Is that correct?
I don't think this specific language includes the equal footing statement.
So we're going to look at the Energy Freedom Act a little bit one more time. I'm going to make this big again. Can you see that, Mr. Searcy? This is, again, we're in section 5841-20, and I would represent to you, this is the provision of Act 62, which requires the commission to evaluate certain things. And right here, non-discriminatory to small power producers. You see that?
That is not showing up hardly at all for me. It's in a tiny, it's in a tiny window on my screen that's completely illegible. I'm trying to change my views. It's not showing up the same as when you showed it before for some reason.
All right. How's that? Is that a little better?
It's still showing it as sort of like a thumbnail image, basically.
All right, I'm gonna go 290. How about that? Can you see that?
Yeah, so it's showing up as a thumbnail on my screen,
Okay.
Mr. Burgess.
Right.
It's like 3 inches across.
Okay, no problem. So maybe it's just the screen that, Mr. Chairman, can you and the others, commissioners in the hearing room, is that viewable?
Yes.
Okay, so Mr. Searcy, you can just look at your direct testimony because this is what you've cited on page 4, lines 8 through 16. That's what we're just looking at here. But go for me down to on line 14 of your direct testimony, where you wrote non-discriminatory to small power producers. That's what the commission has to do in this proceeding, right? When it's setting the rate.
Yes.
Okay. And that would be your assertion that small power producers must be treated on equal footing. That's what non-discriminatory means, right?
Well, and the equal footing statement is lower on this page on line 23 and 24. Cited as footnote 4 South Carolina Code 584120B.
Okay, so is it your testimony that as the commission is gathering and rendering a decision that they do not have to treat the small power producer on equal footing?
No, I'm saying they do have to treat small power producers on a fair and equal footing,
Okay,
as the statute says.
and that's one thing that the commission has to do, correct?
Yes, that's one of a number of things listed
Right.
in Act 62.
That's right. There's a number of things. They got to make sure that the rate is just and reasonable, correct? To ratepayers.
Yes, yes,
correct? They've got to make sure it's in the public interest, correct?
correct.
They got to make sure it's consistent with PURPA and with the Federal Energy Regulatory Commission's implementing regulations and order, correct?
Correct.
And they also have to strive to reduce the risk placed on the using and consuming public, correct?
Yes.
So isn't it true, Mr. Searcy, that 4 out of the 5 things that the commission is required to do under Act 62, they have to take into account the customer, correct?
4 out of the 5, just and reasonable rates certainly take into account the customer, the public interest. I think takes into account the customer, strive to reduce the risk, takes into account the customer. Yeah, and I would say consistent with PURPA, takes into account the customer. So yeah, sure.
All right, thank you, Mr. Searcy. And if I'm doing my math right, you've made 10 recommendations in your testimony that would have the effect of increasing cost to customers. Is that right, Mr. Searcy?
Well, they'd have the effect of making avoided costs more accurate.
Right, and that, in your mind, would be increasing the avoided costs, correct?
Well, in this case, they happen to be increases relative to the company's proposals, but the company's proposals are unreasonable and they're wrong.
Okay.
Avoided costs are what ratepayers would have paid anyway for power, and the company has simply underestimated the avoided costs. I'm correcting those mistakes so that avoided costs are accurate, which is what Act 62 says is required.
Which has the effect of increasing cost on customers, does it not, Mr. Searcy?
No, as I said, avoided costs are what customers would have paid anyway.
Mr. Searcy, who represents customers in this docket?
I would say ORS and the commission.
How about the Department of Consumer Affairs? Would you agree with me? They represent the consumer's interest?
I would, yes.
And you would agree with me, would you not, Mr. Searcy, that the Department of Consumer Affairs is not opposing Dominion Energy's avoided cost rates in this proceeding, are they?
I'm not necessarily aware of all of the Department of Consumer Affairs positions.
You would agree with me, would you not? They didn't file any testimony in this docket disagreeing with or challenging the company's avoided cost calculations or the actual avoided cost rates that the company's presenting in this docket, would you?
That's true, yes.
And ORS, subject to a slight adjustment, they're not opposing the ESC's avoided cost rates either, are they, Mr. Searcy?
Yeah, I don't want to represent that I 100% know all the details of ORS's positions either. I understand that they're not making all of the same recommendations that I am.
Did you read ORS's direct testimony in this proceeding, Mr. Searcy?
I did.
And it's your testimony that you don't understand Mr. Horry's testimony? Did I hear you correctly?
No, I didn't say that I don't understand it. I said that I I'm not necessarily up on all of the details of ORS's testimony. I reviewed it and I see that ORS is not making all of the same recommendations that I am.
When you say you're not up on all the details, what do you mean by that, Mr. Searcy?
I just mean that I could not recite to you from memory the specifics of all of ORS's positions.
Okay. All right. Well, let's talk about the load forecast. I think you took issue with the company's load forecast. And Mr. Searcy, in fact, you criticized Dominion Energy South Carolina's load forecast as being too low, and you would like the company to use a higher load forecast. Isn't that right?
That was my initial concern that I raised in direct when I looked at the company's load forecast that they provided in this docket and discovery that they used for their Plexos modeling. And I compared that to the load forecast in the 2020 IRP. The IRP forecast numbers were consistently higher across all of the years. So that didn't immediately make sense to me. And so I pointed that out in direct testimony. And then I saw the rebuttal response from witness Neely, and it seems that the difference between those two, the IRP and the avoided cost load forecast, was the inclusion of DSM impacts in the avoided cost version. And so, you know, that would be a reasonable explanation for a difference. I did recommend that in future filings, the gross load forecast and the changes due to DSM be broken out and clearly labeled and described in future filings. But in this case, I think you know, that would be a reason that the avoided cost load forecast could be lower than the gross forecast shown in the IRP, and so that seemed to be okay here.
So is it your testimony that you're now accepting of the company's load forecast?
As used for these calculations, yes.
Okay. Thank you, Mr. Searcy. Now, Mr. Searcy, you also criticized the company's effective load carrying capability, or ELCC methodology, for capacity accreditation purposes, correct?
I did, yes.
And if I read your testimony correctly about the ELCC, you basically said, hey, this is hard stuff. And after reading the company's application and its testimony and its discovery responses, I still don't understand it. Is that correct, Mr. Searcy?
No, I wouldn't characterize it that way, Mr. Burgess. What I found when I reviewed the ELCC information that the company submitted in its application and testimony, I found that there wasn't a lot of detail there. And so you couldn't look at that information and do a reasonable evaluation of that methodology and therefore of the result of it. So we asked some discovery questions about the ELCC calculations, trying to get additional detail and information so that I could do a full review of what Dominion performed there. And we got some responses for Dominion. Thank you for those. And some of the responses indicated to me that the data inputs were a little on the sparse side. For example, the responses show that the company used, I think it was 2 or 3 years of both solar production data and load for the calculations, whereas your industry standard ELCC calculation would use 2 or 3 decades, not 2 or 3 years of those types of data. And I also noted, though, that part of the company's response was a SAS program, basically a computer program to do calculations. And that SAS program, because it's in the SAS programming language and requires a license to SAS to use it to run the program, is really unreviewable. I mean, unless you happen to have a license for SAS, which is expensive software, and unless you happen to know the SAS language, which not a lot of people do, that SAS program is unreviewable, and there wasn't any kind of documentation to go along with these things that clearly described in a traditional report format what are all the different methodological steps that Dominion took, what are the different calculations, the equations used, and as you're stepping through all those calculations, what are those calculations finding? Those are what I call the intermediate outputs. So there wasn't any kind of documentation that described all of those elements. And because of that, I couldn't fully review the methodology, even once we had those discovery responses. And again, you know, the information that we did have indicated to me that there's a lack of rigor based on those small data sets and some other concerns that I discuss in my testimony.
Okay. Now, you were present when Mr. Neely testified, correct?
Yes, I was.
And did you hear him inform the commission that you were present in one of the IRP stakeholder meetings?
Yes, I did.
And did you hear him tell the commission that you and he had a dialogue about ELCC and that Mr. Neely asked you for feedback, and to date you've not provided any? Do you remember him testifying to that?
Something to that effect, yes, I do.
And isn't it true, Mr. Searcy, that as of today you still have not responded to Mr. Neely and his discussion with you about ELCC?
I understood in the stakeholder discussion that in response to some of the dialogue on this topic and sort of a larger topic of resource adequacy, that the company decided to schedule a stakeholder meeting in the future specifically devoted to those topics, and they agreed to provide the stakeholder group with materials ahead of time, as some of the stakeholders suggested and encouraged them to do, so that you can have the best possible discussion within the stakeholder group. And so Dominion, I think, responded to that and said, okay, let's set up a meeting that has a dedicated time period to talk about ELCC and related issues. And before we have that meeting, we're going to provide information to members of the stakeholder group that they can review, so they can see, you know, how we think about this, how we perform our calculations now, so that we're then all, you know, ready to have a robust and productive discussion. So generally, I'm looking forward to that future meeting, and I'm looking forward to seeing the materials that the company shares about how they do these calculations and how they think about them. Looking forward to reviewing them and then having that discussion, and I hope it's productive.
And Mr. Cersei, you understand it's kind of hard to have a discussion when you ask for feedback about the ELCC, but yet the other party to that discussion doesn't respond. You would agree with me, that's a difficult conversation to have, right?
Well, I don't know that I would say I haven't, or I didn't respond. I think, you know, these are complex topics, and, you know, as represented by various stakeholders, knowing how the company does calculations and how they think about, you know, different topics is important in terms of stakeholders being able to give feedback. So, you know, to the extent we haven't necessarily seen information from the company there, it's difficult to give feedback. I mean, I would also say that I don't think we're at the end of this discussion. I mean, these stakeholder group meetings, you know, we raise different topics. The company talks about different topics. We have discussions in one meeting, and maybe that's the beginning of the dialogue. Maybe in the next meeting you talk about that same thing some more. You make some more progress and headway, and then everybody, you know, goes back and considers what they heard and what they understood, and you come back and you talk about it some more. I think we're still midway through all of that as it relates to ELCC.
Okay, well, continuing on with ELCC, I thought I heard you testify, sounded like you had a complaint that you didn't have the computer program necessary to run ELCC. Did I understand your testimony correctly on that point?
Well, okay, so the company uses a program called SAS to do their ELCC analysis.
Mr. Cersei, I'm just asking you if you have the computer program. Did I characterize your testimony correctly?
I don't have the computer program SAS, no.
Okay.
And it's not that you have to use SAS to do an ELCC calculation. You could use many different software tools to do that. SAS isn't necessary to it. It's just what the company apparently uses.
Not apparently, they do in fact use SAS, correct, Mr. Cersei?
Well, based on y'all's discovery responses, yes, you use SAS to do this ELCC calculation.
And you understood that through the information that Dominion provided to you and your client, correct?
Yes.
And Mr. Cersei, you do have the ability to run commercial software, do you not?
If I don't have a license, then no, I can't run the commercial software.
And Mr. Cersei, is it your testimony that a company should procure a license for Cersei Consulting to run ELCC?
No, that's not my testimony.
Okay.
I suggested that the company should provide documentation as to how it did its calculations in detailed documentation.
But you also said that you needed a computer program to run it and that you didn't have it, correct, Mr. Cersei?
Well, to clarify, like I just referred to, you could do an ELCC calculation without SAS. There are other computer tools that you can use. You don't have to use SAS. But if I have the documentation, if I know the equations, the data inputs, then I could run my own version of that using a computer program that I do have access to. But I didn't have those those items, and I can't necessarily look at the SAS code and make any sense of it if I don't know that language. And a lot of people don't, most people don't. If documentation were provided that explained the calculations, though, I wouldn't have to understand the SAS code. I could just read the documentations and I could put it into my own computer program.
Right, and I understand you don't know all the details about ORS witness or his testimony, but he didn't criticize the DESC's calculation of ELCC, did he?
Well, I'm not sure that witness Horry did a detailed or attempted to do a detailed review of the ELCC calculation. I think he agreed with the broad concept of ELCC as a reasonable approach to solar capacity accreditation, and I do too. I mean, ELCC is an industry standard approach, but as with many analyses, most analyses in this sector, the devil is in the details. If the details aren't performed in a reasonable way, then the analysis and its results are problematic. And so while I agree high level conceptually, yes, ELCC is a good approach. And I think that's what witness Horry was supporting. Again, if the details are problematic, then the results are problematic. And that's what my testimony speaks to.
You just couldn't understand the data that the company provided you. Isn't that correct, Mr. Searcy?
No, that's incorrect. It's not that I couldn't understand it. It's that the data was, well, part of the data and part of the methodology was unreviewable. The part that I did have, which were some of those data inputs that I referenced, suggests to me a lack of rigor. The part that is in the SAS code, again, is unreviewable. It's not a matter of understanding it or not understanding it. It's that it's written in a computer language.
And that's because you didn't have the computer program, correct, Mr. Searcy?
Well, I don't have a license to the program, and I don't happen to understand SAS language.
Mr. Searcy, I want to talk to you a little bit about avoided energy. And you understand this proceeding is titled Avoided Cost Proceeding. Well, you said CCBA didn't hire you for this proceeding. Did CCL and SACE ask you to calculate avoided energy costs in this proceeding?
They asked me to review the avoided energy proposals and assess them.
But they didn't ask you to calculate avoided energy cost. Is that your testimony?
Well, they asked me to make recommendations on how to improve the company's proposal if there were, ways to do that.
Okay, so it's true, isn't it, Mr. Searcy, that you did not calculate avoided energy costs in this proceeding? Isn't that right?
I did not provide calculations and alternative avoided energy numbers. I provided a number of recommendations related to avoided energy.
But you do know how to calculate avoided energy costs, do you not, Mr. Searcy?
Yes.
And you knew that establishing avoided energy cost was the focal point of this proceeding, correct?
Well, I think the proceeding is focused on avoided energy and avoided capacity and the company's proposals generally. But yes, avoided energy is important for sure.
Okay, and you are aware, are you not, that DESC witness James Neely, he did in fact calculate avoided energy costs in this proceeding, did he not?
Yes.
And you're also aware that ORS witness Brian Ori calculated avoided energy costs in this proceeding too, right?
I'll accept that subject to check, yes.
You can trust me on that one, Mr. Cersey. He did in fact do that calculation. So Mr. Horry could do the calculation, the calculate avoided energy costs, but you could not, correct?
Well, now I'm trying to remember specifically what Mr. Horry calculated. My avoided energy recommendations, one of them was that the gas prices were unreasonable. And
Mr. Horry, excuse me, Mr. Cersey, I didn't ask you about your recommendations. I was just simply asking about whether or not you calculated the avoided energy cost. I heard you say you didn't. I'll accept that answer. We'll move on. Mr. Cersey, you do know that DESC provided CC on SACE with the same information that it provided to ORS. You do know that to be correct, right?
I believe so, yes.
And again, ORS was able to calculate the avoided energy cost rate based upon that information, correct?
Well, and again, referring to the elements of avoided energy that I was focused on in my testimony, the gas prices, my conclusion is the company is using unreasonable gas prices. I don't think Mr. Horry had that same conclusion. In order to recalculate avoided energy with different gas price assumptions, I would need to be able to run the Plexos model. If I had access to that, I could do that, but I don't. So I recommended that the commission require Dominion to rerun the Plexos model with reasonable gas price projections. To my knowledge, Mr. Horry didn't make a recommendation that would require rerunning Plexos.
But you would agree with me, would you not, Mr. Cersey, that the only avoided energy cost calculated and presented in this proceeding to the commission is the avoided energy cost calculated by DESC and ORS? Isn't that correct, Mr. Cersey?
I think that's correct.
Mr. Cersey, thank you very much for answering my questions. Mr. Chairman, I have no further questions at this time.
Commissioner questions. Commissioner Caston.
Good morning, Mr. Cersey.
Good morning, Commissioner Caston.
I understand you're a Clemson graduate.
Yes, sir, I am.
I did not notice any orange on your wall.
Yes. The orange is elsewhere. I should probably have a huge Clemson flag right behind me. I should change that.
Not required. I just assumed it was an oversight.
I appreciate the recommendation.
What was your undergraduate degree?
Undergraduate degree is in biological sciences. I started in engineering and did that for a few semesters. I went into biosystems engineering initially, and as I went into that, I decided I really like the bio part of this, so maybe I'll just go bio all the way. But my undergraduate degree was lots of math, lots of physics, lots of chemistry, and plenty of bio.
I understand. I also note you got a Master of Environmental Management from Duke. When I was in school, if we had an environmental management, no one told me. What exactly is that?
Yeah, sure. So the environmental management program at Duke, it's a 2-year professional master's program. They have maybe 5 or 6 concentrations. They really span a broad range within environmental management. You can do things like air and water quality, ecosystem science, energy and environment, and I did the energy and environment concentration. And so that program for me was getting back to the engineering side that I started at in undergrad. Also, a lot of economics and finance, and lots of power sector specific modeling courses and regulatory related courses.
Sounds interesting. Very interesting.
It was.
Good. Relative to the transparency concern you expressed, I think on page 22 of your rebuttal, and was there any information or specific data request that was made that Dominion did not fulfill?
Okay, let me make sure I'm careful and clear about this response. So, as I acknowledge in my testimony, Dominion gave us responses to all of the discovery that we served on them. Now, our concerns on transparency there were two pieces to that. The first piece was that we had to ask Discovery in the first place on a lot of very, very basic information pieces relevant to these avoided cost rate proposals. The second piece of it was that, and this gets more to your question, I think, even when we had those discovery responses, even when we had the answers that Dominion gave us to our questions, those answers did not actually provide the information that we asked for and needed in some of those cases. And I'll give a couple of examples of that. One of them was that ELCC piece that me and Mr. Burgess just discussed, where part of the answer there was just the SAS code, the computer code used to do this calculation. And so what I testify to is that SAS code is just not reviewable. If an intervener doesn't just happen to know the SAS language, and it's not a commonly known language. I mean, SAS is not like Microsoft Excel. You know, everybody has Microsoft Excel. It's relatively inexpensive. It's a widely known and used software program. SAS is not. And if you don't just happen to have it, if you don't just happen to know the language, then getting that SAS code just doesn't tell you anything. And it would have been easy enough for Dominion to simply write a traditional report that explained, here's our methodology, here's all the different calculations that we did, providing all those equations, providing their intermediate outputs to all those equations, so that an intervener can look at that report, understand fully everything that they did, and audit all of those calculations to see, whether it was reasonable. Okay, another example of this is on the energy pricing periods that I discuss in my testimony. So we asked a discovery question that in effect said, how did you create your pricing periods? How did you pick out the hours that you grouped together to create these pricing periods? And they've yet to answer that. I mean, they provided a discovery response, but as I go through in my testimony step by step, there is nothing in that discovery response that describes how they grouped hours together into pricing periods. I mean, not only that, but we've gone through the application, the discovery, direct testimony, rebuttal testimony, and cross-examination of 2 witnesses on this point, and they still have not just simply described in a coherent way how did we group together the hours. That's not in the spreadsheet. There aren't any calculations that show how they did that, and there's not any description of how they did that. So, I mean, again, that's an example where, yes, they did answer our question. It's not like they didn't provide a response to us, but the response was deficient in terms of actually explaining what they did and legitimately answering our question.
Thank you. Do you recall in Mr. Ori's, I think, direct testimony, when asked a similar question, I think his response was that Dominion was reasonably transparent. And I recall nothing relating to data information requests that were not supplied. So am I hearing you say that Dominion provided everything ORS needed, but not you or Mr. Burgess? Is that what occurred?
I would not think that that's what occurred. Commissioner, let me offer my best guess of what's going on there, and my best understanding of what's going on there is, I think that the ORS and their witness Horry, they did a different review than I did. I think that there seemed to be some different cases where I did a very detailed review of the company's assumptions and calculations, whereas it seems to me from what I've seen, and I don't know this 100%, but it seems to me from what I've seen from witness Horry's testimony, that he didn't necessarily do a review at the level of detail that I did on certain issues. And so if that's the case, then you could imagine that ORS asked some discovery responses. They got the information that they needed to do the review that they wanted to do and decided to do. But when I asked some questions, maybe on some of these points, I was really getting more detailed, I think, than what witness Horry was. Then the responses that I got were not sufficient for what I was needing and looking for. Again, that's my best understanding of what may be going on there.
So what I think I just heard is you believe that ORS didn't drill down as deeply as you did relative to the voided capacity, voided energy, this whole process. And did not need the depth of information that you needed because you drilled deeper than they did in those areas. Is that what I just heard?
Yes, sir. On specific pieces of this, I would agree with that, and that's how I would characterize it as I understand it. Again, I don't know that 100%, but that's as I understand it.
Okay. In your, I think it was direct, could have been rebuttal. You mentioned technology neutral capacity rates, just technology neutral. Is the technology neutral terminology the same as Dominion's solar and non-solar use?
So I use the term technology neutral instead of using Dominion's non-solar rate terms. And I do that because those rate approaches are designed so that whatever technology may use them is going to pay an appropriate amount to that QF, because it pays based on when the QF generates. So it doesn't matter what the technology is. It could be solar, it could be biomass, it could be any type of QF. Under that technology neutral approach, whenever the QF is generating, the prices and the rates are set so that the QF is being paid an appropriate amount based on the system avoided costs. And if they don't generate, then they're not paid for those times. So, for example, under the technology neutral energy rate, if it's a solar QF that was taking that rate, a solar QF's not going to generate at night, right? And so a solar QF would never get paid during the hours, of the nighttime within that technology neutral rate. They would only get paid for the hours during the daytime, and they'd be getting paid the appropriate avoided cost amount, based on what the rate is for that time period.
Okay. But I think I heard you say though, well, let me put it this way. Do you agree that the technologies in many of the cases are distinctly different? There are different technologies in those QFs.
Yes, I agree with that. And I think that the technology neutral rates, though, they are structured in a way that those differences are appropriately captured based on when and how much the QF might generate. And I think it's important to understand and I say this in my testimony, for Dominion, Duke Energy Carolinas, and Duke Energy Progress, the technology neutral approach for the energy rates is what's in place right now for all of their avoided cost tariffs, and it's what was approved by this commission in 2019, because it makes sense to go about identifying in these different pricing periods, what is the system avoided cost during those periods? Maybe from 5 a.m. to 9 a.m., the avoided cost is $35 a megawatt hour. Then from 9 a.m. to 3 p.m., it's $25. I'm just making up numbers. If you set out a rate structure like that, then whenever the QF is generating and whatever type of QF it is being paid appropriately, and it's being paid according to the system avoided costs. Now, the one thing that I would add to that is that those current tariffs, each one of them applies an integration charge if the technology is solar. If it's standalone solar, all three of those operating companies calculated integration charges, and they were approved in the 2019 proceeding. And so it's a technology neutral approach overall, but those tariffs do say if you're solar, you do have to pay this integration charge. And so you are capturing, that solar variability and any impacts there. And my proposal in this proceeding is that the same thing continue to be used. You use a technology neutral energy rate approach, with the asterisk that says for standalone solar QFs, here's the integration charge, and they have to pay that, but others don't. And now understand, I didn't actually review the integration charge itself. I don't know if that was a reasonable proposal or not. That's not part of what I was asked to do. So I'm not commenting on the actual, that actual number, or, whether it should even be above zero at all. But I'm just saying that for the purposes of a technology neutral energy rate, if there is an integration charge for solar, that can be added on to that rate to specifically capture that element of that technology. And that's, again, what's being done in the tariffs right now.
So with that integration charge, if it were just that, then that would, are you saying that would encompass any difference between the technologies, such as the variability, the apparatus required to allow the energy transfer back and forth to occur effectively, efficiently, and intermittency, any reserve energy capacity needed? All that would be rolled up into that, you're saying? Is that what I'm hearing?
That's exactly right. It would be rolled up into that, and the technology neutral rates, as I described, would be paying an appropriate system avoided cost price based on when the solar is generating. So, if it's been pointed out that there's solar on Dominion's system right now, right? And there's about 900 megawatts. And so that 900 megawatts and the impact that it has on prices on the system, that is already baked into the technology neutral rate. So that's already being accounted for. So as long as you include that integration charge, if there is one for solar, if you're using that technology neutral approach, you're then covering everything that you need to cover. You're capturing appropriately the accurate avoided costs on the system. And the reason that I propose this as superior to the company's proposal of the solar QF energy rate is that their solar QF energy rate assumes basically a generic solar production curve for these QFs. And so it may be similar to what the QFs actually generate, but it's not going to be exactly the same. But under the technology neutral approach, it will be exactly the same, because again, they get paid based on what they generate. So in that way, the technology neutral approach is more accurate, and it's capturing the differences in the individual QFs based on where they're located, based on how they're designed, whether they have tracking, single axis tracking, dual axis tracking, no tracking, other design elements of the system. Those things impact how a solar QF generates and when. And that's captured by the technology neutral rate. It's not captured in the company's proposal because the company's proposal just uses just one generic solar production profile.
But you do acknowledge the distinct technological differences amongst QFs, whether that's variable production, dispatchable, or that there are distinctly different technological differences. Okay.
Yes, absolutely. That is true. And that is appropriately captured in the technology neutral approach, as it is now in the current rates.
A couple more things, if I may.
Yeah, absolutely.
On, I think page 26, figure 2 of your direct testimony, I was looking at the, I guess, graph from the study.
Yes.
And a couple of things came to mind as I looked at it and looked at the footnotes. And those footnotes are small. You're talking about small. But I did note that the study is adequacy contribution of solar and storage for Florida municipal utilities.
Yes.
What are some distinct differences that you're aware of, maybe between municipal utilities and investor-owned utilities, that may or may not make a difference?
Sure, Commissioner. So these particular Florida municipal utilities, I looked at some of their data on their system, and I think that they're good reference points to compare to Dominion. They're not perfect, and my recommendations, I think, take into account that they're not perfect references, but these particular municipal utilities, well, first of all, they're in the Southeast, so they experience basically the same climate. That's important here. At least 2 of these utilities are dual peaking utilities. That means sometimes their system peaks during the summer, sometimes it peaks during the winter. Now, Dominion says that it's a winter peaking utility, although in reality it's a dual peaking utility. Sometimes they peak during the summer, sometimes they peak during the winter. They've actually peaked more during the summer in the last decade. So in that sense, it's a good comparison. And, a lot of municipal utilities, they buy most or all of their power wholesale. They don't generate themselves. It so happens that these municipal utilities do not fit that mold. They don't buy very much wholesale. They generate most themselves. So in that sense, they are similar to Dominion as well. And they're fairly large municipal utilities. One of them has got about a 2.5 gigawatt peak. Another one has, I think, maybe a 1.5 gigawatt peak. Dominion's is 4.5, 4.8 gigawatts. So it's bigger, but, these are fairly large municipal utilities. So, in summary, these municipal utilities, again, they're not perfect comparisons, but I think that they are useful benchmarks here for solar capacity accreditation. And, I think what's striking is the 5% value that Dominion came up with versus I think it was 15 to 30% for these utilities. If it had been 5 to 10% for these utilities, I probably wouldn't have said, well, that seems like a big difference. But 5% versus 30% or 5% versus 20%, that's a pretty significant difference. And when I coupled that with the concerns that I had about the ELCC methodology and the rigor, that's what really, overall concerns me about that result of 5% for the ELCC on the Dominion system.
It's kind of interesting to me when I look at this, and in my previous tenure, I spent a lot of time actually trying to compare our utility with the best-in-class municipal utilities, but also the private. So it's almost like the grass is greener on the other side of the fence syndrome, I guess. Matter of fact, compared us to some in Colorado, as a matter of fact.
Okay.
But one thing, and I can't tell you, I'm aware of the names of these, but I know none of the details of these municipal systems. But one thing I do know, at least in South Carolina, relative to distinct differences, because frankly, I used to think, with the inherent benefits or advantages that municipal, or in our case, SPD systems had, I just could not understand how we should have the best rates in the world compared to any investor-owned utility, in my view. Because, one, we weren't regulated by the PSC. Not that that's a bad thing, mind you, but we weren't. We had a separate commission, set our own rates, as do most municipal systems in South Carolina. We didn't pay taxes, and we didn't pay dividends. So I'm not saying that doing comparisons aren't of value or no value, but there are distinct differences that maybe, possibly could be overlooked in some of these things. But I don't know that that is the case, but could be. What?
It's a fair observation. I mean, you have to be careful when you're comparing different utilities and different types of utilities. There are differences, and sometimes those differences can confound the thing that you're looking at to try to get information on. And I completely agree with that. I do again view these utilities and these study findings as a useful benchmark. I don't think that I would never recommend that any of these values from these utilities be directly used by Dominion. I think you always have to use Dominion's own system conditions and data to do these types of calculations. But I do think that given the broad similarities between these utilities and Dominion, these are results that you can that you can look at least for an approximate view of what you might reasonably expect to see out of a calculation like an ELCC calculation. And again, I mean, the thing that to me is concerning is how different 5% and 30% or 5%, 25% are. Those are very different levels for capacity accreditation. And so even though these are different utilities, you know, that's concerning to me, and I think requires further scrutiny. And I think it aligns and is consistent with, you know, again, my observations that their ELCC calculation, the data that they used, and some of the methodological shortcomings, to me, it really calls the result into question.
I understand. You mentioned gas price difference. And I think you state that the EIA gas projections are superior to Dominion's current gas forecast.
Yes.
What is as succinctly as you can deficient about using NYMEX future prices that the company is
okay, what's deficient about using the NYMEX prices is that short-term effects, fluctuations in gas prices over the course of months end up getting carried through the entire forecast all the way to year 10. So like, for example, natural gas prices are changing all the time, and they can change significantly month to month. If it's a mild spring or a mild summer, that might push gas prices down. And Dominion's methodology, where they use those NYMEX prices as their initial point, and then they apply a growth rate to it, that methodology carries that short-term effect all the way through the entire forecast. So, you know, the mild spring in 2021 would be carried through all the way to the year 10 natural gas prices, which is completely inappropriate. I mean, what's happening with the weather in 21 does not fundamentally affect the year 10 gas prices. What drives year 10 gas prices is all the different supply and demand for natural gas at that time. And so that's what the EIA approach captures. It captures those long-term fundamental driving forces of the prices, which are the supply and demand forces. And it ensures that you're not carrying forward these short-term blips in natural gas prices in a long-term forecast.
I understand. But with that thought in mind, thinking in terms of avoided cost being evaluated, say, at a minimum every 2 years, why would these prices not more accurately reflect current prices when compared to gas forecasts in an IRP, which are looking much further down the road?
Yeah, fair question. So the gas prices and the avoided costs are used to create a 10-year standard offer, right? So it makes a huge difference to use a methodology that is getting those 10-year, or, you know, in year 8, in year 6, that's getting those prices wrong. Then when you have a 10-year standard offer rate, those avoided cost rates are going to be unreasonable and wrong. And it is true that, the IRP it's got a longer time horizon, but as it relates to, this particular point that we're talking about, yeah, it's equally inappropriate to carry forward these short-term effects to year 10 as it is to carry them through to year 20 or year 30. So it really, this particular point applies equally in both contexts.
Thank you, Mr. Searcy, and go Tigers.
You're welcome, Commissioner. Go Tigers.
We're in recess until 1:15.